to be covering a few questions based upon the sections of the rules that we've already covered in our course so far. Turning to question 1, the facts state, a judge recently received his appointment to the civil bench in the county. Prior to working as a civil judge, the judge was a managing partner of a large law firm. The firm had a lot of negligence cases pending at the circuit court in which the judge was appointed. The judge did not personally participate in or have specific personal knowledge about any of the cases. While on the bench, the judge did not take the time to note his previous association with the firm or matters pending in his court. The judge was asked to rule on a scheduling motion and did. Is it proper for the judge to rule on this request? The rule that this question is testing is about judges and their need to disqualify themselves from certain types of cases. The rule specifically tells us that judges shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned. The rule goes on to give a whole bunch of instances in which we know their impartiality may be questioned. And one of those instances says that when a judge served as a lawyer in a controversy or was associated with a lawyer who participated substantially as a lawyer in the matter during such an association. This now judge was a managing partner at a law firm who had a ton of cases pending, and therefore he was in association with the lawyers that were handling those pending cases. And now he happens to be a judge, and those cases, or at least one of them, is in front of him. This is problematic. This is precisely one of those situations where the judge's impartiality would be questioned, and therefore disqualification should occur. To disqualify themselves, what a judge does is they have to state on the record the reasons for disqualification. And if the judge thinks that they should be able to handle the case moving forward, they can ask the parties to waive this. However, the judge has to have the parties make their decision and have their discussion about waiver outside of the court's presence. And then they can all come back together and put that decision on the record. Here, we don't have any facts about that process occurring. Instead, the call of the question simply says, is it proper for the judge to rule on this request? So the basic answer to this question is no. This is precisely one of those instances in which the judge should disqualify himself or herself by putting this information on the record and having another judge handle this case. With that, let's evaluate our answer choices. A says it depends on whether or not the judge has any continuing financial interest in the firm. Well, A is wrong. Whether or not this judge can rule on the motion does not only turn upon their financial interest in the firm. Instead, the problem is the judge was associated with the lawyers who were personally and substantially handling the matter when the judge was a lawyer. And now the judge is on the bench, and those cases are in front of him or her. So A is wrong. B says yes, because the matter is simply a scheduling motion. To me, B is kind of saying, like, this isn't a big deal. The judge should be able to hear it. But it doesn't matter how minor of an issue it is that comes before the judge. The judge should just not hear it at all. B is wrong. C says no, because the judge was supposed to put on the record his association with the firm prior to making any ruling. C is wrong. Just because the judge may put their reasons for disqualifications on the record doesn't mean that they can simply move forward with the case. That's not what the rule says. They put their reasons for disqualification on the record, and if they think it's a waivable reason, then they can ask the parties to waive it. So again, answer choice C misses this point and that additional requirement. Answer choice D says no, because the judge was associated with the firm when these matters were pending. And this is exactly correct. This is a situation in which the judge must disqualify himself or herself and didn't. So D is the correct answer. 2. The facts state the local Women's Bar Association for the Association of Justice has offered to sponsor a local judge and her husband to attend a National Judicial Reform Convention and pay for their airfare to the event. The total cost of the airfare is about $1,000. Many of the members of the Association of Justice appear in the judge's courtroom regularly. Is it proper for the judge to accept this offer? The first rule at issue is that a judge may participate in activities that are sponsored by organizations that are concerned with the law, the legal system, or the administration of justice. Here, the judge's activity, attending a National Judicial Reform Convention, appears to be the type of activity that the judge is permitted to participate in, because it's something to do with the Association of Justice. Further, we know judges can accept gifts or reasonable compensation in connection to these activities, so long as their acceptance of the gift or of that compensation does not appear to undermine the judge's impartiality. Now, there's not a hard and fast dollar amount about what would cause us to question a judge's impartiality. So that means what you're looking for here, whenever you get a question like this, you're looking for an answer choice that more or less regurgitates the rule. So the call of the question says, is it proper for the judge to accept this offer? So in an instance like this, I would be a little less concerned with whether or not it's a yes or no answer. Here, I do believe it's a yes answer because we know the judge can participate in these types of activities and judges can accept gifts or things of value or compensation in association with these efforts, so long as the amount does not seem to undermine their impartiality. So again, I don't necessarily think $1,000 would do that. Just keep in mind the language of the rule as we assess the choices. A says yes, so long as the airfare cost does not appear too large and thus appear to undermine the judge's impartiality. So based on everything that we just said, A sounds excellent. Why? Because it's a yes answer, which we feel is correct based upon our interpretation of the rules. But further, it talks about the specific rule at issue. And again, we don't have a hard and fast dollar amount in which this rule is operating under, but instead we have to assess the situation to see if it would call into question the judge's impartiality. And A says just that. So let's hold on to A while we evaluate the rest. B says no, because this constitutes accepting a gift and judges are not allowed to accept gifts. Well, B is wrong. Judges can accept gifts so long as the gift does not call into question their impartiality. C says no, because members of the Association of Justice appear in the judge's courtroom frequently. C is wrong, because as we've learned, judges can participate in activities such as this. This is permissible. And further, they can accept things of value or compensation in connection with their efforts. And D says no, because the Association of Justice is giving a gift to both the judge and the spouse. Well, answer choice D is wrong, because it doesn't matter that it's the judge and the spouse receiving the gift. The rule allows for judges to accept compensation or reimbursement for not only themselves, but their spouse or partner who travels with them. So that means answer choice A is the correct answer. 3. The facts state, a plaintiff sued a manufacturer under a products liability theory. The plaintiff alleges that many other customers have been injured by the same product and argues that his injuries are consistent with other successful litigants. A judge is presiding over this non-jury trial. The judge has her clerk do research on the other litigation that the plaintiff alludes to. The judge also has her clerk contact and question the attorneys and the plaintiffs involved in the other litigation. The judge then decides to side with the plaintiff, since the research conducted by his clerk is consistent with what the plaintiff alleges. Was the judge's conduct proper? The rule that's at issue is that judges are not allowed to engage in ex parte communications or to investigate facts independently. The rule states a judge shall not initiate, permit, or consider ex parte communications or consider other communications made to the judge outside the presence of the parties or their lawyers concerning a pending or impending matter. Here we're told the judge had his clerk talk to non-parties independently and did not have the current parties of the case pending in front of him involved in these conversations. Further, and more problematic, the judge had his clerk conduct independent research or investigate into the facts, which is not allowed. So revisiting the call of the question, it says, was the judge's conduct proper? And the answer has to be a no answer because of this ex parte contact and this independent investigation of the facts. A says yes, because the judge's judgment was supported by plaintiff's allegations. To me, answer choice A is one of those no harm, no foul type of answers, which we know is wrong. It doesn't matter that the plaintiff tends to be consistent in what they're saying with all of the other information that the judge improperly received. It's the fact that the judge took these steps that were not ethical. So A is wrong. B says yes, because the judge has the right to look into relevant facts before rendering a judgment. And B is wrong because the rule specifically says the judge should not be undergoing in these types of ex parte communications, nor having an independent investigation of the facts. C says no, because the judge has engaged in ex parte contacts that might influence the outcome of litigation. C looks pretty good. That's exactly what we said. So let's hold on to answer choice C while we evaluate D. And D says no, because the plaintiffs from the other cases did not testify in the matter. And D is irrelevant. It doesn't speak to the rule or the precise issues being tested. The problem is that the judge reached out and had these contacts and an independent investigation. Now, had the other plaintiffs testified in the case, this might have been a non-issue then, because then the judge would not have had to make an independent investigation, nor would the judge reached out and had those ex parte communications. But they didn't testify. So the judge did take those steps, which is the problem. That means answer choice C is the correct answer.